And, Your Honor, I believe that the individual remaining in the courtroom would like to introduce himself to the court.
Hello, my name is Colton James, family name Waslin. I'm here today by special appearance solely to address discovery and clarify matters from the previous hearing. I am not submitting to the court's jurisdiction for any other purpose and preserving all objections related to jurisdiction. At my last appearance, I was under the impression that there would be no plea entered and the papers would reflect that, as well as me maintaining my innocence, including my constitutional right to assert my innocence. I want to reaffirm that I am maintaining my innocence.
If you want to make a statement on the record here, because we are on the record in court, you have to speak into the microphone so that it can capture your words.
Is this on the calendar? I guess I'm just confused as to what it is.
I want to get to that.
Where's the microphone?
It's sitting at council table right there.
Okay. Would you want me to sit or?
Yes.
Okay.
Let's start again. What is your name, sir?
My name's Colton James, family name of Waslin.
Waslin. Colton Waslin. Cause number 5A0561-562 and cause number 5A0561-563. Mr. Waslin, I see that we're here for...
Buckle up, guys. Today we are going to run through 9 explosive courtroom moments from this compilation. Tight breakdowns, clear takeaways, and exactly why each clip matters. The defendant introduces himself with a special appearance and rejects ordinary court jurisdiction. The judge immediately frames the hearing and reminds him of basic procedure. This opener sets the tone. A courtroom baffled by sovereign rhetoric, legal formality colliding with the defendant's scripted posture. Perfect hook for viewers wondering how far this will go. Start 209, end 420. This segment is a tense tug-of-war about representation. The defendant insists on handling his own defense, while the judge explains that self-representation is a formal process requiring competency checks. The court cites precedent and warns him. Pro se is not automatic. Viewers see the legal system hesitate, rights versus court safeguards, and the moment crisply reveals the limits of theatrical courtroom protest.
A pre-trial hearing. Let me hear from the city first.
I do not believe that Mr. Waslin has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Waslin, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public defender, or whether you would like to hire an attorney of your own.
I wish to do neither.
Well, so, Mr. Waslin, you're not allowed to appear without counsel unless you are asking the court to approve that you be allowed to represent yourself in pro se.
I thought my right was the ability to represent myself.
No, it is not. You have the right to legal counsel at any criminal proceeding. You can be provided a public defender free of charge if you qualify financially, or you have the right, of course, to hire an attorney of your own. If you qualify in terms of what the legal requirements are to represent yourself as your own legal counsel.
Speedy trial pressure dominates this stretch. The defense asks for time to prepare. Prosecutors flag constitutional timing concerns. The judge weighs a short continuance while the clock ticks. This is procedural tension turned dramatic. Will he get the time he wants or be forced ahead under constitutional deadlines? is a technical fight with real consequences for case strategy.
You may do that. I don't recommend it, but we can go through that procedure if that is what you are requesting.
Would I just be able to get a continuance then at that point? Because I need to brush up on a few things so that I may accurately defend myself.
I'd hear from the city. If Mr. Waslin is making a motion to continue, he's not currently represented.
Your Honor, I don't have an objection to the continuance. I don't think we need to do a colloquy today. It doesn't sound like he's quite there where he's necessarily waiving. He's still making that decision. City doesn't have an objection. We would need a speedy trial waiver. I believe Speedy's running well, actually, let me check if it's running from today or if it's running from sorry.
So I see two cause numbers. According to Jabs, pleas of not guilty were entered on the 28th of August.
Which was a misrepresentation of what my intentions were, which is what I also wanted to talk with the court about.
Your Honor, the docket makes it very clear the defendant stated he is innocent of the above charges. That's what was discussed last time we were here. He seems to be rejecting the terms used in this court, but he made an innocent plea on 8/25, and it does look like we would need a speedy trial waiver if there was going to be a continuance today.
I do see that in looking at the court's record, Mr. Wasland, it states that you stated that you were innocent of the charges, which is not the language that we customarily used, but if you are not pleading guilty, you are going to be pleading not guilty. There is no third option.
Here the judge dives into doctrine. Competency to stand trial versus competency to self-represent. Citing Godinez and Indiana versus Edwards, the court explains why some people can face trial but cannot safely act as their own counsel. The exchange is instructional and savage. It exposes the real criteria courts use to protect defendants and the integrity of proceedings, not simply to deny rights arbitrarily.
That said, it was noted as entered back in August, not guilty pleas to both charges, which preserve your constitutional rights to trial and everything else. We will hear your request for a continuance today. If that's what you want, I'm prepared to grant it. Counsel for the city has reminded us that the speedy trial requirement, that is to say the time requirement for you to be brought to trial constitutionally under the state of Washington's laws, requires you to waive that speedy trial if you are asking for more time, because a continuance would take you out beyond that.
Okay, just out of clarification, so the Sixth Amendment does not give me the right to represent myself?
I am not your attorney, Mr. Waslin, and I am not attempting to give you legal advice.
But you are saying that I have to ask to represent myself when I believe that the Sixth Amendment right is the ability to represent myself as like a constitutional right. So I'm asking the court on why that it's not really being allowed in this situation.
Discovery and logistics take center stage. The defendant says he hasn't received evidence. The prosecutor promises compliance but won't hand files today. The judge clarifies the process and sets pickup timelines. This clip is critical for editors. It reveals how procedural delays can derail a DIY defense and why following rules matters more than internet theories about law.
I am not engaging in a colloquy with you about whether or not you're qualified to represent yourself. I think that the court will be willing to do that if you indicate, in fact, that you do want to do that. I had heard that you were asking for a continuance in order to better prepare, which frankly is a good idea.
The continuance was only due to the fact of you saying that I wasn't able to represent myself or act, for myself, defending myself. If I am able to, then I would like to continue and we can go. But if not, then a continuance would be in order so that I can revisit a few things.
So to take the first issue first, Mr. Waslin, you are not constitutionally guaranteed the right to represent yourself in court. You are constitutionally guaranteed the right to have an attorney represent you. If you wish to represent yourself in court, the court may engage in what is known as a colloquy with you at a later time, that is to say, not today, in order to see if you are qualified to competently represent yourself. That's something that can take place at a later date. The court will hear your motion to be qualified as a pro se defendant. I also heard that you are asking the court to continue these cases so that you can have time, presumably, to prepare for that colloquy, if that's what you want. I'm prepared to grant it. I will tell you, though, that I cannot grant it if you do not wish to waive your speedy trial right, because your trial is currently set. Pardon me, it's not set, but we have speedy running when?
From the 28th of August.
That would take us sometime into next month. How much time are you asking for as a continuance, Mr. Waslin?
Well, honestly, I only came here by special appearance to assert innocence and request discovery.
The court issues concrete orders, update addresses, don't drive without valid license, sign a promise to appear, and notes the defendant's request for a continuance. These are the mundane but deadly serious conditions that, if violated, lead to warrants and remands. Viewers see how small administrative obligations become high-stakes obligations in real criminal cases.
But given the matters that...
Your not guilty pleas have already been entered at your last court appearance.
which I didn't want to plea or contract with the state or city of Bellingham, which was the issue at hand. I just wanted to maintain my constitutional right of innocence is...
Your constitutional right to a trial and the presumption of your innocence, as well as your right to an attorney and all of the other rights that were discussed, are maintained.
I would like to maintain all rights and not just the ones discussed.
I would like to maintain your rights as well, Mr. Waslin. I'm asking you, as to your speedy trial right, which is a rule of court here in the state of Washington,
Okay.
if you're asking for a continuance, you need to tell me whether you want to go to trial before November 28th, or wish you'd rather to continue until after that date.
We can go before if you want.
I don't have any position in the matter, Mr. Waslin. You're appearing before this court.
I'm fine with that.
And
You're
Your
fine
Honor,
with what?
With
Perhaps-
going before.
perhaps what might make sense is if we just set it over without a speedy waiver, do a very short set until the presiding judge is back and can go through the colloquy, perhaps a week or two.
Certainly, I'll say that, Mr. Waslin, we can continue your matter inside of the time remaining for the speedy trial requirement.
Okay.
But it will be a very short amount of time to prepare for trial if that is what you wish to do without waiving speedy.
That is fine, as long as I am able to pick up my discovery today at the end of court. That'd be totally fine with me, because they have not done their obligation of submitting it to me by CR R 4.7.
So, Mr. Waslin,
Shift to the second scene. Bond argument for a disruptive defendant. The judge recounts prior disruptive behavior and warns about courtroom decorum. Deputies listen, the defendant protests, and the court balances release conditions against public safety. This moment is high energy. Courtroom conduct directly impacts whether someone stays free pending trial.
Mr. Mula here. Excellent. This is case number 25M1510. I understand, Mr. Sullivan, that your office might have a conflict with this case?
Yes, Judge, and I believe it was filed with the court.
Okay. So let me unmute Mr. Mula. So good afternoon, Mr. Mula. This is Mr. Sullivan. He's here with the Office of the Public Defender.
Yes.
They have a conflict with your case, so if you remain in custody, I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's the right. So
Yeah, sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Your Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So, yesterday, Mr. Mula appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Mula, and then I'll make a ruling regarding bond.
Yes, ma'am. I was illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So, yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So, also, I work with the homeless community here.
Okay.
I work with all the programs.
Okay. If you could wait just a sec, what I'm going to do is ask you questions under the statute. I'm going to ask.
The judge announces bond terms. Co-signed personal recognizance. No contact with the named victim, and pretrial supervision. Charges are read, trespass and obstruction, and the defendant's confusion about victim makes for dramatic audio. This clip gives viewers the outcome of the bond fight and a concrete sense of the constraints placed on release.
Ask you questions under each subsection. Don't talk about the allegations, okay? So, what is your full name and date of birth?
I'm Johnny Lay, free and living man, all rights reserved.
In the event that the court were to release you on a personal recognizance bond, would you sign that bond?
Yes, ma'am.
Okay. Let's see. What are your ties to the jurisdiction?
To the jurisdiction.
To Boulder
I've
County.
been here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay. And just wait. Ms. Mayfield, you said you don't know of any record you could make under E or F.
I do not.
Okay. All right, Mr. Mula, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who is the victim?
Let me take a look.
And what are the charges? I didn't hear any charges. So.
Yep. So let me tell you, you were, I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons,
I don't have an address.
Oh, just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what the charges are. You're charged with the unclassified petty offense of third-degree trespass and the Class 2 misdemeanor of obstructing a peace officer. As it relates to the address you are...
Final dramatic scene. A defendant discovers an active warrant and is remanded while protesting that deputies can't touch him. The courtroom escalates into physical removal and incredulous argument. This is pure courtroom drama, law versus performative sovereignty, and it ends the compilation on a visceral note showing real consequences for persistent noncompliance. If you found this breakdown useful, like the video and subscribe to the channel. We'll see you in the next video.